Okay, are you ready to get seriously fascinated? Because today we're diving deep into something really cool, the South African law of evidence.
Yeah, we're gonna be using actual cases and laws, statutes.
It's kind of like a legal thriller, except instead of chasing a suspect, we're chasing the truth. And the clues are like pieces of evidence.
Exactly. We're gonna be looking at how evidence is judged to see if it's, admissible in court and how much weight it carries. And also how different types of evidence, like similar facts or character evidence, even stuff like previous statements, how they all come into play.
Oh, and get this. We even have a case involving a police dog.
Really? A dog?
Yeah. Back in 1920, the court said that any evidence that came from a dog, like sniffing out a suspect, was inadmissible.
Oh, wow.
But it's not actually that simple.
So, what's interesting here is that while, yeah, a dog sniffing something out might be unreliable on its own, if you add enough other evidence to explain how that dog can, tell scents apart and track a specific person,
Uh-huh.
then it could actually become admissible.
So, a dog detective could be legit. That's crazy.
Yeah.
We'll also be digging into something you might have heard of, the cautionary rule in sexual assault cases.
Right.
And spoiler alert, it's been challenged quite a bit, in recent years. And for good reason.
Yeah, absolutely. We're going to explore how, societal biases have kind of impacted how reliable people think witnesses are in these types of cases.
Uh-huh.
And we'll see how modern, legal thinking is moving towards a more just and balanced approach.
Okay, so this deep dive is going to be your express lane to understanding this super complex but also super important area of law.
Definitely. And hopefully by the end of this, you'll be able to look at any legal case you hear about, whether it's on the news or in your, favorite true crime podcast, and you'll be able to analyze the evidence that they present with a more informed and critical eye.
All right, so let's jump right into Study Unit 1 from this document we have. It's the foundation for everything else we'll talk about. It just gets us familiar with the main concepts and sources of the South African law of evidence.
Exactly. And Chapter 1 really zeroes in on the history and the sources of this law. What's kind of cool is that South African law of evidence is actually based on English law.
Wow.
Yeah. So a lot of the principles we'll be discussing have roots that go back centuries in, legal tradition.
So we're not just talking about some dry, boring legal rules here. We're talking about a system that's been shaped by history and, things that happened before.
Yeah.
But what does all this actually mean for us, practically speaking?
Well, it means that when we're looking at a specific case, we need to think about not just the specific things that happened in that case, but also the bigger legal context. And we have to be aware of, the different sources of law, like legislation, common law, and even customary law. All those things might be important to the case.
Okay, so it's like building a case, brick by brick, but all those bricks are coming from different places and different times.
Right.
Let's move on to Chapter 2 now. This one focuses on, what exactly is law evidence and what's its role in the whole legal system?
This chapter emphasizes how evidence law focuses on proving facts in legal disputes. It helps you understand the rules and procedures that, control how evidence is shown and just in court.
Okay.
Yeah.
So it's not just about finding the evidence, it's about making sure it's presented in a way that's fair and reliable.
Right.
And ultimately helps the court make a just decision.
Exactly. Chapter 2 also gets into the different kinds of evidence, like oral evidence, documentary evidence, and real evidence. We'll look at those more later.
Okay, so we're starting to see the big picture here. But let's get to Chapter 3, which tackles relevance. That's the absolute foundation for whether evidence can even be used.
Yeah, for sure. Chapter 3 emphasizes that evidence can only be used if it relates to the specific facts that are being argued about in the case. Think of it this way. If a piece of evidence doesn't help to prove or disprove something important to the case, then it's basically irrelevant and the court shouldn't even consider it.
It makes sense that you wouldn't want to, clutter up the courtroom with information that's not even relevant, right? But how does the court actually decide what's relevant? Is there a special test they use?
Oh, yeah, you're absolutely right to point that out because it's not always super obvious. Chapter 3 talks about the logical relevance test.
Oh, okay.
Which basically looks at whether the evidence could make a fact in the case more or less likely to be true.
So it's all about logic and probability, right?
Exactly.
Does this piece of evidence make it more likely that something happened or less likely?
Precisely. And if the answer is no, then that evidence is basically out of the picture.
Okay, so relevance is super important, and the courts have this logical test to figure it out. But what happens when you start dealing with different types of evidence?
Yeah.
Like similar facts or character evidence. Don't those have their own, like, specific rules?
You're already starting to think like a lawyer. That's actually what Study Unit 2 is all about. It dives into like when you can use different types of evidence.
Okay.
And trust me, each category has its own like whole bunch of rules and little nuances.
This is where things get interesting. Let's start with similar fact evidence, because I've always found that kind of fascinating. It's like, can you use someone's past actions to predict what they'll do in the future?
That is the big question.
Yeah.
And Chapter 4 explores it like, under what conditions can you use evidence of someone's bad behavior from the past?
Right.
Remember the R.B. Solomon's case?
Uh-huh.
That case highlighted that similar fact evidence has to be relevant to what's happening in the current case.
Right. It's not just about showing that someone's, like, generally a bad apple. It's about finding specific links between what they did before and the current accusations. But what about someone's character in general?
Yeah.
Can the prosecution just say, hey, this person's shady, so they're probably guilty?
That's a great question, and that takes us right into Chapter 5, which is all about character evidence. The main rule is that the prosecution can't just start talking about the accused's bad character.
So no character assassination in the courtroom.
Nope. But Chapter 5 does outline some times when character evidence can be brought up.
Okay.
For example, if the accused decides to bring up their good character to help their defense, then the prosecution can counter that by introducing evidence of their bad character.
Ah, so it's like a strategic game.
Yeah, like chess.
You only play the character card if your opponent plays it first.
Precisely. And then there are cases where the character evidence is so closely tied to the facts of the case that you can't avoid it.
Like what?
Like, if the accused says they were acting in self-defense, then their history of violence might be relevant to see how likely their claim is.
Okay, so character evidence is definitely tricky, lots of nuances and legal things to consider. But what about confessions? Aren't those considered pretty solid evidence?
You'd think so, right? But Chapter 6 explains that confessions aren't always so straightforward.
Really?
Yeah, South African law puts a lot of emphasis on the idea that a confession has to be made freely and voluntarily.
So no forced confessions, no pressure, no shady tactics, right? But how can we know for sure if a confession was really given without any pressure? What does the court look at?
Great question. Chapter 6 dives into all the things the courts consider, like the accused person's mental state, whether there were any threats or promises made, and whether they had a lawyer. The case of S.V. Mavuso is a really good example of how these factors are used in a real case.
S.V. Mavuso. Okay, I'm writing that down. So confessions can be strong evidence, but they have to be obtained the right way.
Exactly, and that's a theme we see throughout evidence law. It's a constant balancing act.
Balancing act.
Yeah, between trying to ensure justice is served and protecting individual rights. Yeah, and that balancing act is especially important when we're talking about evidence from pointing something out, which is what Chapter 7 is all about. This is where things can get, like, a little bit fuzzy.
Fuzzy how?
Well, because pointing something out can actually be seen as, like, an admission of guilt, even if it's done by actions instead of words.
Oh, okay.
Yeah.
So if a suspect leads the police to, like, a hidden weapon, even without saying I did it, that action could be used against them in court.
Exactly. And just like with confessions, the courts really look into whether the pointing out was done freely and voluntarily. Like, was there any pressure or coercion? Did the accused understand their rights? All those things are super important for the court to consider.
Okay, so even nonverbal actions can be really important in court.
Yeah.
But what about those, like, juicy secondhand accounts?
Uh-huh.
You know, the stuff that maybe wasn't directly witnessed, but everyone's talking about?
Right.
I'm talking about hearsay.
Hearsay. The thing that causes so much trouble in, like, all those courtroom dramas.
Right.
Chapter 8 goes deep into this area of evidence law, which is all about trying to balance, wanting to consider all the information out there, but also making sure that information is actually reliable.
So is hearsay ever allowed in court? Or is it always a no-go?
The general rule is that hearsay evidence is not admissible.
Okay.
And Chapter 8 explains why. It all comes down to reliability and fairness. So the person who made the original statement, they're not in court to be questioned.
Uh-huh.
So there's no way to check if they're telling the truth or challenge what they said.
Right, so you can't just quote someone who's not there to defend what they said.
Yeah.
But are there any exceptions? Like, I can imagine some cases where a secondhand account might be really important for understanding what happened.
You're absolutely right. There are exceptions, and that's where things get really interesting. Chapter 8 lays out several exceptions to the hearsay rule, and each one has its own like specific requirements and safeguards.
Oh, okay.
For instance, things like dying declarations, statements made as part of someone's job, and even like spontaneous exclamations might be allowed under certain circumstances.
So it's not a total ban on hearsay.
Yeah.
It's more like they're very specific about when they'll allow it. It's like a safety valve.
Exactly.
Okay, that makes sense. Now, Chapter 9 deals with opinion evidence, which I feel like could get really messy. Can anyone's opinion just be considered evidence?
Not really. Chapter 9 explains that the general rule is witnesses can talk about facts, not opinions.
Okay.
But, of course, there are exceptions, especially for expert opinions. We'll get to those later.
Okay, so if I see a car accident, I can say what I saw, but I can't just give my opinion on who's at fault, right?
Precisely. Figuring out fault often needs, like, special knowledge, stuff like understanding traffic laws or accident reconstruction. And that's where expert witnesses come in.
Okay, so opinions are usually out unless they come from the qualified expert. Got it. Now, Chapter 10 covers evidence of past convictions.
Yeah.
That seems like it could really bias the court against the accused, don't you think?
You're totally right. Chapter 10 explores that tension, the idea that everyone's innocent until proven guilty, but then you might bring up their past convictions, and that could prejudice the court.
Right.
So generally, you can't use evidence of previous convictions during a trial. The focus should be on what's happening now, not someone's past mistakes.
But are there ever times when past convictions are allowed? And what's there to stop unfair prejudice?
Chapter 10 does outline some exceptions where previous conviction might be allowed, like if it's relevant to prove a specific part of the current crime or to counter a defense that the accused has brought up.
Oh, okay.
But even then, the court has to carefully balance things out. They have to weigh how useful the evidence is against how much it might unfairly prejudice the case.
So they can't just throw around someone's past convictions willy-nilly.
No, they have to be careful.
Now, Study Unit 3 dives into the world of witnesses, which seems pretty crucial for evidence law, right? I mean, witnesses are often the ones giving those first-hand accounts of what happened.
Absolutely. Witnesses are key.
Yeah.
Chapter 11 lays out the groundwork for understanding their role in the legal process, covering things like competence and compellability.
Competence and what now?
Compellability. Basically, it's about who can testify and who can be forced to testify.
Oh, okay, I get it. So not everyone's automatically allowed to take the stand and spill the beans.
That's right. Chapter 11 outlines the requirements for a witness to be competent.
Okay.
Like, they have to have enough mental capacity and understand that it's important to tell the truth. It also goes into situations where some people, like spouses or lawyers, might not have to testify because of privilege. Yeah.
So confidence makes sure the witness is reliable, and privilege protects certain relationships and, like, confidential conversations. But what about compellability? Can anyone be forced to testify even if they really don't want to?
That's where things can get tricky. Chapter 11 explains that while usually competent witnesses can be compelled to testify, there are exceptions. For example, someone accused of a crime can't be forced to testify against themselves. That would violate their right to silence.
Ah, the right to silence. That's a crucial safeguard, right, to protect people from incriminating themselves. But let's move on to Chapter 12, which focuses on questioning witnesses. This is where things get dramatic, like in all those courtroom shows.
Yeah, for sure.
Right.
Chapter 12 breaks down the different stages of questioning a witness.
Okay.
It starts with examination in chief, where the side that called the witness asks them questions to get their story out. Then there's cross-examination, where the other side gets to challenge the witness's version of events and try to poke holes in their story.
Ooh, cross-examination. That's where those heated moments happen.
Yeah.
Where lawyers try to catch the witness out in a lie or find inconsistencies.
Exactly. And then, if needed, there's re-examination, where the side who originally called the witness can clarify things that came up during cross-examination.
Okay.
It's a very structured process to make sure both sides have a chance to present their case and challenge the other side's evidence.
It sounds like a dance with very specific steps. But let's move on to Chapter 13 now, which deals with real evidence, the tangible stuff that can really bring a case to life.
Absolutely. Things like fingerprints, weapons, DNA samples, those are physical objects that can directly connect a person to a crime or an event. Chapter 13 explores what's needed for real evidence to be used in court, and it really emphasizes the importance of authenticity and relevance.
So just like with other types of evidence, we need to be sure the real evidence is actually what it's supposed to be, and that it actually helps to prove or disprove something in the case.
Exactly. Chapter 13 also highlights the chain of custody, which makes sure that the evidence hasn't been tampered with or contaminated, from the moment it was collected to when it's presented in court.
Right, because if there's any doubt about whether the evidence is legit, it could throw the whole case off. Now, what about Chapter 14? That one deals with documentary evidence, all those written records that can be so important in a case.
Things like contracts, emails, medical records, they can tell a story all on their own. Chapter 14 explores the rules for using documentary evidence in court. And, just like with real evidence, it's all about proving authenticity and relevance.
So, same as before, we need to make sure the document is actually what it claims to be and that it actually has something to do with the case.
Exactly. Chapter 14 also gets into the best evidence rule, which basically means you have to bring the original document unless there's a good reason to use a copy.
Interesting. So no sneaky photocopies or like doctored documents allowed. Now, Study Unit 4 is where we get into evidence in specific types of cases. This is where we see how all these legal theories actually play out in real-life scenarios, right?
Absolutely. Chapter 15 focuses on criminal cases, while Chapter 16 dives into the specifics of civil cases. We'll see how the standard of proof is different between the two.
Standard of proof.
Yeah, and how certain rules of evidence might be applied differently depending on the type of case.
Ooh, this is where it gets juicy. So is the standard of proof like stricter in criminal cases than in civil cases?
You bet. Chapter 15 emphasizes the beyond a reasonable doubt standard for criminal cases.
Okay.
It means the prosecution has to present evidence that's so strong that it leaves no reasonable doubt that the person is guilty.
Wow, that's tough. So they have to really scrutinize every piece of evidence to see if it meets that standard.
Exactly, and that's why investigations, evidence collection, and how the evidence is presented in court all have to be done very carefully.
Okay, so criminal cases need beyond a reasonable doubt, but what about civil cases? What's the standard there?
Chapter 16 explains that for civil cases, the standard is on a balance of probabilities.
Okay.
This basically means the person bringing the claim has to prove that their version of what happened is more likely than not.
So it's not about erasing all doubt. It's just about making their side seem more likely.
Exactly, and this makes sense because civil cases usually involve disagreements between individuals, not someone being accused of a crime.
Okay, so criminal cases versus civil cases, different standards, different rules. I'm starting to see the distinctions. Now, Study Unit 5 takes us into a really sensitive and complex area. Evidence in sexual offense cases.
Right. Chapter 17 takes a close look at the unique challenges you face when dealing with evidence in these types of cases. Historically, there were a lot of misconceptions and stereotypes about sexual offenses, which led to the development of the cautionary rule.
The cautionary rule, I think I've heard of that, but I don't really know what it is. Can you explain it?
Basically, the cautionary rule said that courts had to be extra cautious with the testimony of someone making a complaint in a sexual offense case.
Oh?
It was because of worries about false accusations and because people thought victims were particularly vulnerable.
So they were like inherently skeptical of people making accusations in these cases.
Yeah, you could say that.
But that seems kind of unfair, doesn't it?
That's exactly why the cautionary rule has been debated so much over the years.
Uh-huh.
Critics say it's based on gender bias and that it undermines the victim's credibility.
So what's the deal with the cautionary rule now? Is it still a thing?
Chapter 17 explains that the traditional cautionary rule has been mostly abolished in South African law.
Really?
Yeah. The courts have realized that it was based on outdated ideas and could lead to unfair outcomes.
So they're not automatically assuming that people reporting sexual offenses are unreliable anymore.
Exactly. Now the focus is on judging each case on its own merits, looking at all the evidence, and judging all witnesses by the same standards, no matter what type of crime it is.
That sounds like a good step forward, making things more fair and just. But I'm wondering, what challenges are still out there when dealing with evidence in these types of cases?
Well, one of the biggest challenges is dealing with delayed reporting, which happens a lot in sexual offense cases.
Delayed reporting.
Yeah.
Okay.
Chapter 17 goes into the reasons for this, like fear, shame, or the psychological effects of trauma. It also looks at how the courts assess the credibility of someone who didn't report right away, recognizing that delayed reporting doesn't automatically mean their testimony is false.
So it's all about understanding the context, the person's individual situation, and the potential impact of trauma.
Right.
Not just dismissing them because they didn't report it immediately.
Precisely. And that requires sensitivity, expertise, and a commitment to being fair throughout the legal process. Now, let's move on to Study Unit 6, which explores how the Constitution shapes evidence law. I'm guessing this is where we see, those conflicts between individual rights and freedoms and the need to uphold the law.
Exactly. Chapter 18 gets into the impact of the Constitution on whether evidence is admissible. It looks at how fundamental rights, like the right to privacy, the right to silence, and the right to a fair trial, can all influence what evidence is allowed in court.
It's a super interesting area of law because it forces us to confront those tough questions about where we draw the line between personal freedoms, and trying to achieve justice.
So if evidence was obtained in a way that violates someone's constitutional rights, does that automatically mean it can't be used in court, or are there, like, exceptions?
That is the million-dollar question. Chapter 18 looks at the exclusionary rule, which, like we discussed earlier, generally prohibits using illegally obtained evidence.
Right.
However, it also outlines exceptions to this rule,
Okay.
like the good faith exception, where evidence might be allowed if the police were acting in good faith, believing they were doing things by the book.
So it's not as simple as just throwing out any evidence that was obtained improperly.
Nope.
There's a whole process of weighting how bad the constitutional violation was against the public interest in prosecuting crime.
Exactly. And finding that balance is never easy. It requires thinking about the specifics of the case, the legal principles, and what the impact will be on society as a whole.
Okay, so constitutional rights, exclusionary rule, exceptions, balancing act. It's complicated, but really important. Now, Study Unit 7 introduces a concept I find fascinating. Statutory presumptions. What exactly are those, and why do they matter?
Statutory presumptions are basically legal shortcuts.
Shortcuts.
Yeah. It's where the law says certain facts can be assumed to be true unless proven otherwise.
Oh, interesting.
Chapter 19 explores this, showing how they can shift who has the burden of proof and how that affects things in a trial.
So instead of the prosecution having to prove something, it's on the defendant to disprove it. Doesn't that seem like it could give the prosecution an advantage?
You're totally spot on. And that's why statutory presumptions have to be looked at really carefully to make sure they don't violate fundamental rights, like the presumption of innocence.
So are there any examples of these statutory presumptions being challenged because they might violate the Constitution?
Chapter 19 talks about several examples, like the presumption about drunk driving,
Oh, yeah.
where a certain blood alcohol level is assumed to mean you're intoxicated.
Right.
People have challenged this, arguing that it goes against the idea of being presumed innocent and unfairly puts the burden of proof on the defendant.
Interesting. So even though statutory presumptions can be helpful for making legal processes more efficient, they have to be created and used carefully so they don't trample on people's rights. Now, Study Unit 8 is all about how much weight evidence carries and how it's evaluated. This is where we shift from whether something's admissible to, like, how persuasive it is, right?
Exactly. After evidence is considered admissible, the court has to figure out how much weight it carries, its probative value.
Okay.
Chapter 20 looks at all the factors that affect this, including how credible the witnesses are, if their statements are consistent, and whether their testimony is backed up by other evidence.
So it's not just about whether the evidence is allowed in court, but also about how convincing it is, like how much it actually helps to prove or disprove something in the case.
Exactly. And that's when things get a bit subjective. The court has to weigh everything, consider both sides' arguments, and ultimately decide how persuasive each piece of evidence is.
Okay, so there's not like some magical scale in the courtroom that gives each piece of evidence a score.
Not quite, but there are legal principles and guidelines that help the court through this complicated process.
So what are some of the main things the court considers when weighing evidence? Like, what makes one piece more convincing than another?
Well, one of the most important things is the credibility of the witnesses.
Right.
Is this person believable?
Uh-huh.
Do they have any biases or motives that might be influencing their testimony? Have they contradicted themselves or been inconsistent with their story?
So it's not just what they say, but how they say it, how they act, and whether their story holds up under scrutiny.
Exactly. And then there's corroboration. Is there other evidence that backs up what the witness is saying? For example, if a witness says they saw the accused running away in a red car,
Yeah.
is there any other proof, like traffic camera footage or other witnesses that confirm there was a red car there?
So it's like building a wall, right? Each brick is a piece of evidence.
Yeah.
And the more bricks you have, the stronger the wall.
Exactly. The more corroboration there is, the more seriously the court will take the evidence. Of course, how much weight evidence carries can change during the trial, like if new information comes out or as witnesses are cross-examined.
Right, like that whole beyond reasonable doubt standard we talked about before. The prosecution has to build a case that's strong enough to eliminate any reasonable doubt.
Exactly. And that applies not just to the whole case, but to each piece of evidence, too. They all have to be weighed and assessed to see how much they contribute to the overall picture.
Okay, I'm getting a better sense now of how this evidence evaluation process works. It's less about those dramatic moments and more about a careful step-by-step analysis.
And that's what makes it so fascinating. It's a mix of logic, legal principles, and human judgment.
Speaking of human judgment, let's talk about expert witnesses. You know, those specialists who bring their expertise to the courtroom?
Ah, yes, expert witnesses.
Yeah.
They're the bridge between specialized knowledge and the legal system.
Uh-huh.
They're super important in helping the court understand complicated issues that the judge or jury might not be experts in.
So if there's like a really technical DNA analysis or a complex medical question, they'd call in an expert to explain it.
Exactly. Expert witnesses can testify on all kinds of things, from forensic science and engineering to economics.
Wow.
Their job is to give unbiased, objective opinions based on their specialized knowledge.
Okay, so they're not working for either side. They're more like neutral explainers.
Precisely. Their duty is to help the court, not to take sides.
But how does the court know if someone is actually qualified to be an expert witness? Do they have to pass some kind of, like, expert exam?
That's a great question. There's no specific exam,
Okay.
but there are legal criteria that the court uses to assess their qualifications.
Oh, okay.
Basically, the expert has to have special knowledge, skill, experience, training, or education that's relevant to the issue in the case.
So it's not just about having a fancy degree. It's about having real-world experience and deep knowledge of the subject.
Exactly. And the court will thoroughly check the expert's credentials and past work to make sure they're really qualified to give an opinion.
So let's say we have an expert witness and the court says they're qualified. Can they just say whatever they want, or are there rules about what opinions they can share?
There are definitely rules. One of the big ones is that their opinion has to be based on facts that are admissible in court.
Okay.
They can't just speculate or rely on hearsay.
Right, because we're trying to build a case on solid evidence, not just guesses or rumors.
Exactly. And their opinion has to be relevant to the facts of the case, just like any other evidence.
Okay, so expert witnesses, specialized knowledge, relevance, admissible facts, it's all connected. But what are some real-life examples where expert testimony has actually made a difference in a case?
A great example is the SV Malangut case. This one involved a complicated medical question about the cause of death.
Okay, SV Malambu. So did they bring in, like, a medical examiner or something?
Exactly. They had a forensic pathologist testify to help the court understand the medical evidence. They needed to figure out if the accused's actions were what caused the victim's death.
So the expert's opinion was crucial in determining whether the person was guilty or not.
Absolutely. It shows how important it is to have qualified, unbiased experts to help the court understand complex issues.
Okay, so we've covered expert witnesses, their qualifications, the rule for their testimony, and even looked at a real case where they played a key role. What's next in our editor's journey?
Well, let's switch gears and talk about documentary evidence, those written records that can be so important for a case.
Documentary evidence. Okay, so we're going from talking to writing. But what makes documentary evidence so special? What challenges does it present?
One of the main challenges is authentication.
Okay.
Like, how do we know if a document is real? Was it really created by the person they say created it? Has it been changed at all?
Right, because anyone can fake a signature or change a document these days. How can the court tell if a document is the genuine article?
That's where the rules of evidence come in. There are special procedures for authenticating documents.
Okay.
This might involve witness testimony, expert analysis, or even comparing the document to known samples of someone's handwriting or signature.
So it's like a forensic investigation, but for paper.
Exactly. Once a document has been authenticated, the court then looks at how relevant it is and how much weight it carries, just like with any other evidence.
Okay, so authenticity, relevance, weight, it's all connected, same as with other types of evidence. But are there any real-life cases where documentary evidence really made a difference?
A good example is the SVN Lavu case. This one involved a disagreement about a contract, and the court had to carefully look at whether the contract was real and what it actually said.
Okay, SVM Lavu. So it was like a fight over a contract.
You could say that, and the court's decision on the documentary evidence was what decided the whole case.
So it's not always about dramatic witness testimony or shocking physical evidence.
Yeah,
Sometimes it's those seemingly boring documents that hold the key to the truth.
absolutely, and that's why it's so important to understand the rules about documentary evidence, not just for lawyers, but for anyone who wants to really understand the legal system and how justice is served.
Okay, so we've talked about documentary evidence, the challenges of proving it's real, and even looked at a case where those written records were crucial. What's next in our evidence adventure?
Well, let's dive into a type of evidence that can be really challenging, but also very revealing. Real evidence.
Real evidence. Okay.
Think about things like fingerprints, weapons, DNA samples,
Oh, I get it.
those tangible objects that can directly link a person to a crime scene or an event.
Okay, so now we're talking about the physical stuff, the things you can actually touch and see.
Right.
What are some things to consider when dealing with real evidence?
One of the most important things with real evidence is the chain of custody.
Chain of custody.
Yeah, it's about making sure the evidence hasn't been messed with or contaminated.
Okay.
Like, was it collected, stored, and transported properly?
Right, because if someone planted evidence or messed with it, that could ruin the whole case.
Exactly. That's why it's so important to have a clear and documented chain of custody.
Uh-huh.
Every single person who handled the evidence, from the crime scene investigator to the lab technician, has to be accounted for.
So it's like a relay race.
Yeah, like a relay race.
Each person has to pass the baton carefully and make sure it doesn't get dropped or switched out.
That's a great way to put it. Any break in the chain of custody can create serious doubts about whether the evidence is reliable.
Okay, so chain of custody, tampering, contamination, it's all about making sure the evidence is trustworthy. But are there any real cases where these issues have come up?
Definitely. A case that shows just how important chain of custody is SV Mbatha. It was a murder case, and a weapon was supposedly found at the accused's home.
Okay, SV Mbatha. Did they question the chain of custody in that case?
Absolutely. The defense lawyers argued that there were gaps and inconsistencies in the chain of custody, which made them doubt whether the weapon was actually found at the accused's place.
So did the court allow the weapon to be used as evidence?
In the SV Mbatha case, the court really looked into the chain of custody and decided that, yes, the weapon could be admitted as evidence.
Okay.
But because of the inconsistencies, it didn't carry as much weight.
So even if they allow the evidence, if the chain of custody is messed up, it can still make the evidence less believable.
Precisely. It shows just how important it is to have meticulous procedures and documentation when you're dealing with real evidence.
Okay, so real evidence, chain of custody, making sure it's trustworthy, how much weight it carries, it's all connected. What else is there to explore in the world of evidence?
Well, let's shift our focus now to a type of evidence that can be particularly challenging but also really insightful: electronic evidence. Think about emails, text messages, social media posts, all those digital footprints that can tell us a lot about what someone did and what their intentions were.
Electronic evidence. Okay, so we're going digital now. What are some of the unique challenges with this type of evidence?
One of the big ones is authenticity. Like with documents, how do we know if an email or a text message is real?
Yeah.
Was it really sent by the person they say sent it? Has it been changed in any way?
Right, because anyone can make a fake email address or change a digital document these days.
Exactly. And that's where the rules of evidence come into play, just like with regular documents. We need to figure out if the electronic systems are reliable, verify who the sender or creator is, and make sure the evidence hasn't been tampered with.
So it's like being a digital detective, right? Tracking down those electronic clues and making sure they haven't been messed with or planted.
You got it. And this often means working with computer forensics experts who can analyze the electronic systems, get back deleted data, and trace where the electronic evidence came from.
Okay, so authenticity, digital forensics, making sure it's reliable. It's like we're making sure that this electronic evidence is legit. But are there, like, real-life cases where this has actually happened?
Definitely. A case that really shows the challenges and, well, the possibilities with electronic evidence is SV Smith. It involved a bunch of threatening emails that were supposedly sent by the accused to the victim.
Okay, SV Smith. So did they actually accept those emails as evidence?
That's the big question. The court in SV Smith had to really look into whether the emails were authentic. They looked at the email headers, IP addresses, all those technical details to see if they could be reliably linked back to the accused.
So it's not just about reading the email. It's like going under the hood and checking all the technical stuff to see where it really came from?
Exactly. And in this case, the court eventually decided that the email could be used as evidence, but they didn't carry as much weight because they weren't totally sure if only the accused had access to the computer that sent them.
So even if they allow the electronic evidence, if there's doubt about where it came from, it weakens the case.
Precisely. It shows how important it is to have careful procedures and expert analysis when dealing with electronic evidence.
Okay, so electronic evidence, authenticity, digital forensics, how much weight it carries, it's all connected. What's next on our evidence exploration?
Well, let's change gears a bit and talk about a type of evidence that can be tricky to handle, but it can also be very telling: circumstantial evidence.
Circumstantial evidence.
Yeah, it's evidence that relies on making inferences and deductions rather than direct observation.
Okay, that sounds kind of like a logic puzzle. So how does circumstantial evidence actually work in court?
Imagine building a case, brick by brick, right?
Uh-huh.
But instead of having someone saying, I saw them do it, you're using a bunch of interconnected facts that, when you put them all together, point to a specific conclusion.
So it's less about a direct account and more about putting together a bunch of clues.
Exactly. And while it might not be as dramatic as a confession or an eyewitness, circumstantial evidence can be really persuasive when it's presented the right way.
Okay, so let's say in a case they find the accused fingerprints at the crime scene. Would that be considered direct evidence or circumstantial?
Good question. The fingerprints themselves would be real evidence.
Okay.
But the fact that they were at the crime scene, that's circumstantial evidence.
Why is that?
Because, yeah, the fingerprints put them at the scene, but they don't directly prove they committed the crime.
Oh, I see. So there could be another explanation, right?
Correct.
Like maybe they were there earlier or had a reason to be there that's not related to the crime.
Precisely. And that's why circumstantial evidence has to be looked at very carefully.
Uh-huh.
The court has to consider all the possible explanations, the innocent ones and the incriminating ones, before deciding anything.
Okay, so circumstantial evidence, inferences, deductions, looking at all the possibilities. It's about connecting the dots and seeing the whole picture. Are there any real-life cases where circumstantial evidence has played a major role?
A good example is the S.V. Blom case. This one was about a murder, and the prosecution's case was built almost entirely on circumstantial evidence.
Okay, S.V. Blom. What were some of the clues in that case?
Well, there were financial records showing that the accused had gotten money from the victim's death.
Uh-huh.
And there was witness testimony that put the accused near the crime scene around the time of the murder.
So no smoking gun, but a bunch of clues pointing of the accused.
Exactly. And the court, after considering everything very carefully, decided that the circumstantial evidence was strong enough to convict the accused.
So it's not just about the amount of evidence, but the quality, how convincing it is, and how all the pieces fit together to tell a story.
Exactly. That's why you often need a really good prosecutor who can present the evidence in a clear, compelling, and logical way.
Okay, so circumstantial evidence, inferences, looking at the whole picture, it's all about building a strong case from a bunch of connected facts. We've learned so much already, but I know there's still more to cover. What's next?
You're right, we've covered a lot of ground, but there are still some key areas to explore. So far, we've mostly focused on the rules for different types of evidence. But now let's zoom out and look at the big picture principles that guide how we evaluate and weigh all this evidence.
Ooh, that sounds interesting. It's like we've been learning the individual moves in a game, and now we're going to learn the overall strategy.
It's a perfect analogy. Chapter 21 in that document we've been looking at focuses on this, exploring the principles behind how we evaluate evidence and the role that logic and reasoning play.
So it's not just about memorizing a bunch of rules, it's about understanding the logic behind them and applying those principles to each case.
Exactly. This chapter really stresses how important it is to think critically, to be skeptical, and to be able to weigh different arguments and interpretations of the evidence.
That sounds like a valuable skill not just for lawyers, but for anyone who wants to be a well-informed citizen. It's about being able to look at information, decide if it's credible, and form your own conclusions.
Absolutely. And this chapter also introduces the concept of probative value.
Probative value.
Yeah, it basically means how much a piece of evidence actually proves or disproves a fact that's important to the case.
So it's not just about whether you're allowed to use the evidence, but about how much it actually matters, how convincing it is.
Exactly. Evidence might be admissible, but if it's weak, unreliable, or contradicts other evidence, it might not have much probative value.
Okay, so probative value, credibility, corroboration, it's all starting to click now. Are there any specific ways that courts use to evaluate evidence?
Great question. Chapter 21 explores a few of those. One common approach is to look for corroboration, which we talked about before. That means looking for different sources of evidence that all point to the same conclusion.
So it's like two heads are better than one, but for evidence.
Exactly. The more independent sources of evidence you have, the stronger it becomes.
Uh-huh.
Another technique is to look at the consistency of the evidence. Does the witness stick to the same story? Does the physical evidence match what the witnesses are saying?
So if there are inconsistencies, that could be a sign that something's not right.
Exactly. And then there's plausibility. Does the evidence make sense when you consider everything else you know about the case? Does it fit with how people usually act and with the laws of nature?
So if someone says they saw a pig fly, the court might be a little skeptical.
You got it. The court has to use common sense and logic when evaluating evidence.
Wow, this is all making so much sense now. I feel like I can actually analyze evidence and form my own conclusions. But before we wrap up, is there anything else we should touch on? Any last bits of wisdom for our listeners?
I think it's important to remember that evidence law is always changing. As technology changes and society's values change, the rules about evidence have to keep up.
That's a good point. We've already seen how digital evidence has changed investigations and trials.
Right.
And who knows what's coming next.
Exactly. So the key is to stay informed, keep learning, and keep those critical thinking skills sharp. Because the search for truth never really ends, and evidence is the tool that helps us find it.
Well said. Okay, everyone, that wraps up our deep dive into the South African law of evidence. We've explored the main principles, talked about some really interesting cases, and hopefully gotten you curious about this complex and always evolving field.
And remember, the search for truth is an ongoing journey. Stay curious, stay critical, and keep those legal minds working.
Exactly. Until next time, keep diving deep.